Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Hey, so in this episode, I'm super excited to be interviewing Reza Davani. Reza is basically the man, and I didn't know about this amazing trial lawyer until I listened to his interview on Elevate with Ben Gideon, which I was just telling you, Reza, I've listened to 5-6 times. I shared it with everybody in my office. I just truly thought it was such a good interview, and because of all the great information you had to share, I'm super psyched to have you on Just Verdicts here today. So thanks for being here, man.
Thanks for having me. I'm always happy to talk shop. I love this profession that we're in. It's creative, it's interesting, and so when someone's willing to sit down, recorded or not recorded, I'm generally available to chat. I love it. Thank you for having me.
I'm pumped, and just listening to the way that you think and strategize about your trials really resonated with me because I might have different terms for how I sort of think about the way I approach my trials, at least the fun way, the strategic way. And I think you have a ton to share on that. But first, want to talk a little bit about your background. So, when you interviewed with Ben on Elevate several months ago, you were talking about this great $9 million nursing home bed sore case that you had recently got at that point. And then I saw that since that time, you were named the 2024 Maryland Trial Attorney of the Year afterwards. So congratulations on that accomplishment.
Thank you. Appreciate it. Very much appreciate it.
Was it a big gala, a big ball, big celebration, or was it more low key?
Yeah, they had a big event, as they do with these things. Me and the attorney who tried the case with me, Tara, was also there and also properly named Trial Lawyer of the Year. So it's a dual award that we both held together because we brought home that change in the verdict the prior year and worked on another case as well. So they made a big event out of it, but it was good food, so I was happy.
That's awesome, and a major and well-deserved feather in your cap. So I understand you're a partner at Ketter Brown Associates, and you practice predominantly in Maryland, right?
Predominantly in Maryland, and I'd say almost exclusively SNF cases, SNF, nursing home cases. Here and there, some ALF and other mixed mal, but I would characterize myself as a nursing home or nursing home abuse lawyer.
And I know that, over the course of your career, you've worked in some different areas of plaintiff's work. You've done mass tort, you did, lead exposure cases, you've done auto, some trucking and so forth, and now kind of settled into kicking butt in nursing home cases. Well, I guess, what is it about nursing home cases that appeal to you so much that, you've continued to really dig in and get better at them?
I started with a big mass tort firm here in Maryland. I think that has framed how I look at all my cases. Everything to me looks like a mass tort. Car accident cases look like mass torts. Nursing home cases, they look and feel like mass torts to me. I guess I'm stuck with, I guess you call it this lens that I'm interpreting everything. And in mass torts, it's always about how this product got on the market. Why did this happen? What did the entity do to allow this happen? What shortcuts did they take? And if there are none, you don't have a case. If there are, that's really what the case is about. It's not just the injury. Well, why did this injury happen? What were the standard of care breaches, the violations? And they usually end up being kind of technical. And I've taken that throughout my whole practice. So when I did auto cases for a while, I was a fairly annoying plaintiff's practitioner in the auto world because you got these in-house lawyers from State Farm and Allstate, and they roll in there and they're expecting a 30-minute depo, and I take a 3.5-hour depo where I'm cross-examining the defense on the rules of the road and the different statutes and the Maryland driving manual. I'm like, well, it says you should keep a 3-second space. Did you leave the 3-second space? Did you follow this requirement? What are the reasons for this requirement? Well, if you did, when did you break? I would go through this entire analytics based on sort of what the standard and the conduct should be and reverse engineer. And I do the same thing in nursing home world. And in nursing home world, it's so fun because you have so much material to work with. The downside of nursing home work for anyone who hasn't done it is it's incredibly laborious because these patients are in there for months or years. So you're looking at 10, 20,000 pages of medical records, assuming there's no admissions in interim to any other facility. But the upside, in my view, is if you're willing to roll up your sleeves and really start analyzing it, it's just a gold mine of Play-Doh is what those records are that you could really start to work with to find out what happened and why. And if you're willing to spend the time to puzzle together all the different pieces of the chart, you start to see the picture of what really, really happened. So I think it's just fun because there's more material to work with. And that's why I enjoy doing nursing homes so much.
So as I, told you, what I wanted to cover today was the way you think and apply, what you've coined as the landmines. And we typically hear about, watching out, using focus groups to look out for the landmines in our own cases. But you're talking, about a more proactive approach using, the facts of the case to create landmines for the defense to step on that can create favorable situations for you. And then we're also going to talk about another great verdict that you obtained recently, using that approach. But with this landmine concept, and there's a lot of people that listen. Myself, I'm a medical malpractice predominant practitioner, and a lot of times my cases have huge amounts of records, long timelines afterwards. What are you looking for? How do you approach? Okay, a case comes in, you've made the decision that there's enough to get the records to start going through them. What is the filter? What's the lens you're looking at on how to work that case up and whether it checks the box for Reza to take this case or not?
Yeah, I'm looking for a story. Before I even care about the medical issues, I look, there's an obvious first level filter, right? Like I'm not going to take a stage 2 pressure ulcer case, right? It's got to pass some obvious filters, but assuming that it passes the obvious filters, it would warrant the time to look at the case. I'm really hunting for a story. Is there a story here that has a lot of juice, right? Like just an obvious example, the patient develops stage 3 or 4 bed sore, but the nursing home doesn't write it anywhere in their charts. And then they discharge the patient to home or to the hospital, and the family discovers they could see their mom's spine right through a hole in her back, or the hospital sees that and documents it. Well, what the heck was going on? That wound was there for gosh knows how long, and they're sweeping it under the rug. That's quite a story there. So that's the kind of thing that jumps out at me when I'm looking at the records, and because it's, at least for me, it's not a volume practice, med mal cases, nursing home cases. So I'm putting eyes on the records myself, and I'm reading them for kind of a vibe of what's the story of what happened here. Does it smell like a med mal, or does it smell like a mass tort? Is kind of one lens of looking at it. And I'm looking for something that smells like a mass tort, something that has a broader explanation for what happened. Sketchy stuff is going on, stuff that doesn't make sense that's going on. The nursing home cut corners, the nursing home tried to sweep things under the rug. The nursing home mischaracterized or mislabeled stuff that's obvious, black and white, not messy medical explanations. This looks like something that I would take a verdict on. And I know a lot of folks do it differently. That's my view on every nursing home case I take. I have the luxury of having 20 some firms send me their nursing home cases, but I'm looking at them, and if I take it, I'm going to take a verdict on it. I won't take a case thinking, all right, maybe I can squeeze out 100 or 150 on this. I'm not looking to squeeze value out of something I genuinely don't believe on. When I file the case, if they make the right offer, that's great. If not, the intention is we're going to take a verdict because I found enough good vibes in it that I think the energy, the story of the case, irrespective of what the defense is going to try and do, what they always do, muddy the medicine. Irrespective of that, anticipating the muddying of the medicine they're going to try and do, is a story powerful enough that I think will overcome that. So it's kind of a vibe check, depending on how many records. I mean, it's a process that will usually take me at least a day. So me or another lawyer is going to go through that vibe check, run through all 20,000 whatever it is records, and get a feel for, all right, do we think that this is going to pass the smell test? Because every case is also reviewed by medical experts, and they come back and they say, does it have medical merit or not? But I don't just take that and say, all right, it passed. Now it's 2 levels, right? The first level screening, the second level merit review. It needs to pass the third test, which is that vibe test, which is really how I'm deciding what I'm going to do with the case.
It sounds like Because I've heard you talk before, and a lot of what you're looking for are, what you've dubbed, red flags or landmines against the defense, against the defendant. But from the vibe perspective, it sounds like you're balancing that with, some of the factors that go in their favor or go against your client or the estate or so forth. And I'm imagining by vibe, it's more of a feel rather than, well, I've got 10 points against the defense and 3 points against the plaintiff. Is that kind of ultimately what it boils down to?
It's large. I will say it's largely a vibe, although I will say I run because I do nursing home pretty much exclusively. There's good ROI for me to invest in research for those, and so I have a large data set of research and a lot of focus groups and a lot of sort of evidence of how to value the cases. Some of it I kind of have a feel for, like let's just call it a point system. So it's largely a vibe system, but there is some mathematical component to it that lets me figure out how strong the vibe is. So it's a combination of just gut with some combination of data from all my focus group research that is compiled, which lets me know how much juice I might get from certain pressure points. So it's a combo factor of the two.
So two things. The second point will be, segue into the Anderson versus Alice Manor case that we're here to talk about today. But first, for people that haven't heard, the original podcast that I listened to you with Ben Gideon, can you tell us what your definition of a landmine is, and sort of, what are you looking for? What is it, and how do you incorporate it into your trials to improve your chances of winning?
I start with this framework, being trained and having original mentors that were obsessive rule followers. I will call them technocrats. Start with clean hands and follow the rules, right? What goes around comes around, and you can't have unclean hands. That's the starting premise. But assuming you're doing what you're supposed to do, assuming you're following the rules, assuming you have clean hands, and you're litigating ethically, then what should happen is if the other side does the same thing, you shouldn't have any landmines. But the defense can't help themselves. They are who they are, and the lion's share of them play games. The folly of their ways are you play stupid games, you win stupid prizes, right? So they tend to do things in discovery that in essence it's sort of sabotaging the evidence, and they hope that it goes away when discovery's done. And they want to go to trial and say, ta-da, hi ladies and gentlemen, I'm Mr. Great Lawyer and I'm a nice guy, and let me tell you about all the nice things my client did and why he's innocent. Well, no, there's blood on your hands, right? And there's things they've done that's inappropriate, but their folly is they make it such that it addresses the evidence, right? It sabotages the evidence. And one example I've given is a nursing home case, for example, where there's only 3,500 some pages of medical records, but rather than just giving us those 3,500 pages, the facility will give us 2,500 pages. Then they'll come in another round and they'll give us 1,500 pages. Then they'll come in another round and 3,000 and 2,000. And each time there's a few new records, but I'm ripping my hair out trying to figure out which records are new records. And I can't take the risk of being wrong, and I can't take the risk of just extracting and giving those to my expert. At least I'm not going to take that risk. So I'm giving them all to my expert and I'm helping guide them, but they're going to do their work. They're like, I respect Mr. Davani, what you told me, but I'm going to read these records. Next thing you know, your expert has a $20,000 set of invoices, and then defense is excited. Oh, Dr. Plaintiff's expert, you got $20,000 in invoices. You're skewed and you're biased and you're making all this money in this case. Well, no, Mr. Defense Counsel, let's just make sure we're all speaking the same language. There's only 3,500 pages of medical records here for this facility, but for whatever reason, you gave me 9 different versions of it. Each one had snuck and buried within it a few different pages. And by the way, it looks like you only gave your experts 3,500 pages, but you made me sift through 10,000 or 15,000 pages of medical records. You guys made it actively more difficult for me to find the truth by burying it across all these pages, and that's why my invoice is what it is. That's a classic landmine that comes up in nursing home cases. I'll tell the defense, you need to stipulate to the fact of these records and when you gave them to me, or I'm going to let the expert know. I'm going to forward your emails to my expert, you better not come at him and start talking about how much you made because you have unclean hands on that issue. You caused that issue. And then the back and forth starts from there. But that's an example of a landmine, right? Something that the defense thinks is a weapon for them, but they try to fabricate that weapon by creating the issue. And there is a proper way that you're ready to deal with it to expose the game that they played. Now, I call them landmines because it's not like a booby trap that I made, right? It's not something, I'm not telling plaintiffs' lawyers, go out there to do this. I'm saying pay attention to what the defense is doing and pay careful attention to when they do something that's actively sabotaging the evidence or fabricating evidence, and be ready to address that at trial because they set the booby trap for themselves. It's a landmine. If they step on it, you will help it blow up in their face. But theoretically, an ethical, proper acting defense lawyer will not have any landmines because they'll be doing the right thing. They won't be playing those games. But like I said, I have not encountered a case yet doing nursing home work in the last 4 or so years. I have not encountered a case where I don't have close to half a dozen landmines or more in every one of them.
So it sounds like, the landmines predominantly, as you think through them, are defense attorney created, issues that, you're not forcing upon them. But if they continue down a certain path, they're inevitably going to step on them and it looks really bad. It impacts their credibility. There are other issues, maybe these are what you would dub the red flags, that are issues you're looking for in the record that are going into, sort of the plus column for, I'm going to go try this case. And, those might be like, for instance, you talked when you tried, auto cases, it would look, was the person driving an expensive car? Did they have a callous reaction after the fact to the injured plaintiff? Like they just sat in their car on their cell phone or something like that. So obviously the landmine component where, the defense may just inadvertently step on it themselves. When you have those, I think you mentioned it, the Mandelism of, I just can't get over issues. Can you talk about your approach of whether you're addressing those in opening as opposed to, letting them kind of, come out during the testimony for the first time? I mean, how do you balance those two?
Yeah, well, first on the red flags, I think you can look at a case and identify something that's a red flag. And that red flag can also become a landmine depending on what the defense lawyer does with it. Because sometimes the defense lawyer will make a mishap. They'll take something that's a red flag, something that's maybe good for us, an obvious thing for us, and they'll try to spin it. But they're so worried about it that in trying to spin it, they create this altered, vulnerable version of that fact. And then you just let them step on it. And all you got to do is go back to the original fact to show that, wait a minute, here's the truth. Here's what the defense lawyer came up with after we filed the lawsuit. Somebody's clearly gaming the evidence. And so it suddenly is something that was just a red flag is now much worse. And it's become this landmine. So you're getting double points and just you sitting back drinking a mojito, watching the defense out of nervousness blow up their own case, right? That's something that I see happen at a pretty high frequency because if something is an obvious red flag, they're not idiots, right? Male defense lawyers are not idiots, right? They're seeing those same things that we're seeing, and then we have to kind of let them deal with it. In terms of how I deal with it once we're in the courtroom, I generally will address it in opening. I think perhaps the difference between what I do and what some other folks do is I don't aggressively address it in discovery. So if something's a red flag in the medical record, well, the medical record is the medical record. It's right there. I don't need to do anything with it, right? Those medical records are admissible. They're relevant. They're the injury records for the injured claimant who's making an injury claim. So I don't need to do anything with those records. So I just sit back and I watch those records. I know that issue is there and available. And then when we get to trial, I know that it's there. I generally don't depose defense experts. I get the sense that defense lawyers are very eager for us to depose their experts because they want to know what we're going to do. I know there's different schools of thought on this. I'm of the school of thought of I'm just going to trust the fact that I'm going to cross the expert at trial, and I'm not going to reveal or tip my hand by taking their deposition. That's just my personal style. I think there are appropriate times to take a defense expert deposition, but I'd say 99% of the time I don't. So the first time the defense will see how I'm framing the red flags or that they accidentally stepped on a landmine is my opening statement. I'm generally going to reveal it in the opening statement. Now, how much of it I reveal in the opening statement depends on how many things I have, how many mistakes and red flags are there. If I have 10 awesome things that I'm dealing with, maybe I'll only reveal 5 in opening or 6, and I'll reveal the rest throughout the trial. If I only have 4 or 5, well, maybe I'll only reveal 3 of them. So I make a strategic decision, but I generally will not reveal all of the what I think are the best parts of the case in my opening. I will not. Look, I'll say this: the defense is going to see the opening. They're going to try to change and pivot the story. We've all seen it, right? They see the opening, they're like, oh crap, that's what Reza's going to do. I finally see it. Then Tuesday, Wednesday, Thursday, they're cleaning it up, trying to spin a new reality. Friday, they put on their first witness. I show up and I drop 3 more truth bombs on them. And suddenly they're like, oh crap, now we have to change our story again. And the jury's sitting back there saying, wait a minute. You told us the light was red, and then you said the light was green, and now you're saying the light is yellow. Like, and what happens in the courtroom is it's really a credibility issue, right? And the jury starts to lose trust with the defense, and this is so proper. It's so proper because, and this is something I get real emotional about. It's proper because the defense is gaming the system. I genuinely feel this. They're gaming the system. They are trying to create a story to defend their negligent client. And here's why, one of the reasons I really feel that way. I get tons of referrals from cases, right? I get this large volume, let's say 100 nursing home referrals. Out of the 100, maybe I'll say, all right, let's look at the 20. Of the 20, maybe 5 come back positive merit review. Of that 5, maybe 3 pass my vibe check. Then you have the certifying expert. The certifying expert is another level of medical review I have. It's separate from my preliminary nurses and experts that review, right? Because those preliminary people are cheaper, realistically, right? The certifying experts are more expensive. So then I have a 4th level of review. It's past 4 smell tests at this point. I'm filing a case because something negligent actually happened, and I know the truth, and I feel the truth about what it is, and multiple people have agreed with me about what really happened there. We filed that case. The defense doesn't have that. They're stuck with it. Some insurance company hit up an insurance firm that needs business and said, will you take this case? I said, we would love to bill hourly for that. Of course. They take it and they try to make the best version of the reality they can, which always ends up being them changing or trying to change the reality. So they are trying to create a different truth. And a good defense lawyer does a good job creating a different truth. And they convince juries. But we're not just filing every case as plaintiff. We'll go bankrupt if we just file every case or file cases hoping we can squeeze out some value. We'll go bankrupt on that. It's not a profitable scenario. We're filing viable cases or cases that someone else is telling us is viable, at least in the med mal context. So we have that strong authority on our side. We believe in that reality, and the defense is just trying to create a different reality. In their effort to create that different reality, they are making mistakes because they have to try to stretch the truth, bend the truth, dance around the truth, amend the truth, explain away the truth. And what happens when you get to court, juries are seeing that. They're seeing that, hey, the plaintiff's lawyer came in here telling us the light was green. The whole time they said the light was green. Everything since they've been involved says the light was green. The facts they have from before the lawsuit says the light was green. Whether they're right or wrong, there's one thing we know for sure. We could trust this fellow or this lady that they think the light's green, and that's what they tell us the whole time. If I'm going to ding them, it's because I really don't think the light was green. The defense, however, is all over the place. They're all over the place. And that costs them a ton of credibility. We just have to be accurate and careful in calling them out on it in a way that's not snarky and rude and makes us look worried. As long as we accurately call them out on it. And that's what Landmines accomplishes, right? Now we've gone full circle. Landmines helps accomplish that. Exposing the defense to say, hey, they don't even believe that the light was yellow or red or whatever color it is, right? It's the classic example of they say it wasn't my dog, but if it was my dog, he didn't bite you. But if he did bite you, he didn't bite you that hard. And if he did bite you really hard, well, you really weren't that hurt. And if you were, you recovered pretty fast. You have 4 fallback arguments. How do you really believe what the truth is? Why are you arguing that the dog didn't bite you that hard if you're saying it wasn't your dog? Like, that should be the end of it. That's all your eggs in one basket. If that's honest to God's truth, the only thing that you need to convince the jury of, it's not my dog. I don't even need to talk about all this other stuff because it doesn't matter. It's not my dog, folks. So it just doesn't make common sense. It doesn't make common sense, and that's the link that's missing for the dark side. Their story doesn't always pass common sense, and regular folks in the jury are stepping in there, just hearing the two versions, and they're like, one of these lawyers is not being real with me, and they can figure out pretty quickly if you use the landmines and the red flags pretty quickly which side it is, which is trying to bend the truth, and which side it is, which is being truthful. And
You hit on so many really good points there, and kind of an overarching idea or just kind of feel. And I don't know if you kind of felt the same thing. I mean, everybody always talks about, everybody wants to talk about, their victories, but if you try a lot of cases to juries, you're going to lose. And I've certainly lost my fair share before. And I find in lead up to the cases that I've won versus the cases that I've lost, that uh, because in those winning cases, the facts are better, just your level of evidence is more superior. It just feels smoother and it's less difficult. Whereas the tougher ones, the 50-50 cases, it just feels like you're having to jump through too many hoops. And what I see translate a lot of times is that when it's a tougher case, I feel like I have to kind of, make this extra something happen to get that, little push to get to the jury. I'm more inclined to make mistakes with it, step on my own landmines, create problems, impact my own credibility versus, when you're totally in the right going in, it feels smoother. You get into trial and you can almost feel that the defense is going to make mistakes trying to, come up with their, alternate reality version because their version of the case is just not, it's not as compelling. It's not as true as yours is.
yeah, when they're doing what they're doing to defense, which is trying to create this alternate reality, they have to thread the needle because they have to. It's like they want to create this line that's the story, but for it to work, they have to bend all these other pieces together to fit the line, to thread it perfectly. And when all these pieces are bent, there's such a small window for them to get through, for all those pieces to fit together in a right way where the story could, in some universe, actually have happened. And that makes it very, very vulnerable, very, very vulnerable. And proper cross will usually expose that. Will you expose that, right? Basic, simple polarization techniques will reveal that, wait a minute, if we're off by an inch, suddenly your whole house of cards crumbles. It does. So is that right? And
Oh
if you
yeah.
ask proper hypotheticals to them, and they'll crumble on that, and then suddenly it's exposed.
And a compelling, just overall issue that you see come up, and it's a great cross piece is, the litigation initiated argument or diagnosis or the new causation that was never ever mentioned in the medical records. It was never talked about. I'll see that in birth injury cases a lot where they're coming up with new explanations for how this baby was injured before, and it's like, but nobody ever said that ever, and it's never been said in their medical records. But here you are, a paid expert, coming in and coming up with this completely new, for the first time, theory about what actually caused this issue. And we see that in all sorts of cases when the medical side of things, and now, and you've talked about it in pressure wound cases, that the defense is going to do all sorts of gymnastics to not call it a pressure wound and label it as something that was caused by an underlying medical condition or late manifested trauma induced injury and so forth, anything but the pressure injury. But that's just another landmine that becomes a great piece that you can expose and hurt their credibility and improve yours at the same time.
Yeah, 100%, 100%. I mean, if I look at the case and I don't see those truths, I'm not taking the case, right? Because we're not paid by the hour for the work that we do, right? If I'm going to take a med mal trial to verdict, I'm spending 50 plus $1,000. I'm not going to just risk that for fun or risk that to get 150 and have the client left holding the bag because the only people who got paid are experts and plaintiffs' lawyers. No, it has to make mathematical, economic sense for the victim, and that means it has to be a really strong case. And so I think we're on the right side of this, right? If we're doing proper case selection, and I think we're on the right side of this.
So let's take Reza Davani's awesome trial theories and approach to trial and actually apply it to a real case study, which was this trial in Nelson Anderson versus Alice Manor, which was a great verdict you got on the heels of your $9 million nursing home verdict, where, I heard you talk about first, and I would encourage people to go and listen to that case. But tell us about, give us a summary of the facts of the Nelson Anderson case, what you were dealing with, because it was a very, very difficult factual case, but what it was you saw in the records that made you want to go try this case.
Yeah, well, let's balance. Let's start with the difficulties of the case. It's a pressure ulcer case, and the patient had peripheral vascular disease. I know a number of lawyers won't even touch a PVD pressure ulcer case. So I had peripheral vascular disease. I won't go through the list. It was a dozen some comorbidities that would affect circulation. So a lot of negative red flags for us on that list. It was a long-term patient, not a rehab patient. He had prior wounds in the nursing home that had healed, right? So the nursing home said, look, we were doing our job because, look, we healed other wounds. He got COVID, and roughly a month-ish after getting COVID, he got the ultimate wound that was the subject of the lawsuit. Well, that's a pretty good temporal relationship for the defense, right? What's the only thing that's different, ladies and gentlemen? He got COVID. And everyone, all the literature about COVID-related wounds and circulatory issues. So we had that problem. COVID was on the death certificate. That was a pretty big problem. That was going to be an issue for us. He was effectively homeless. He didn't have, one of the main things when I entered nursing home, everyone said is, you got to have a good family. Well, this guy did not have a good family. He had no family. There was no support system there. It was purely a survival action case because he didn't have any children. He didn't have a spouse. He didn't have any parents. In every direction you go, he had no wrongful death beneficiaries. What he had was an advocate. He had someone who was a cousin who grew up being sort of like a sister to him, very close to him, who just had a bad feeling. Like, I just have a bad feeling about what happened at Alice Manor. I have a bad feeling about what happened in this nursing home. And so she decided to call and have someone look into it because it didn't pass her smell test. Her gut check said something's wrong here. But she had, unfortunately, health issues that came up during the case because she got COVID. And she ended up moving out of state to live closer to her family. So she wasn't even available to attend trial. So talk about, we talk about the empty chair defense in one sense. Well, we had an empty chair for the plaintiff. Only people at trial was me and my co-counsel, Lauren Henry, and no client. Because of that, we couldn't get introduced into evidence to have authenticated any pictures of our client either. So we have an invisible client. We just have what I refer to now as the concept of a plaintiff. No pictures of the wound either. So we have the concept of a plaintiff, the concept of an injury. The jury can't see the victim. They can't see the injury. Everything's just sort of like conceptually being talked about for them. It was pretty bad. And then we had turning and repositioning failures across the whole tenure. And so the facility was saying, well, if we were being if we were careless the whole time, he should have had this wound earlier, right? And this wound would have been worse earlier. But its relation to COVID suggests that's the one outlying factor. So there were, gosh, if that wasn't enough, the cherry on top was 11 days before trial, a new expert who I was working with for, I don't know, over a year, had never testified in trial before, got cold feet and no-showed. She basically hit me up 11 days before trial and says she's not coming. Wouldn't respond wouldn't pick up my call. I was frantically calling, texting, email, wouldn't respond. She just decided that she's going to ghost me. I kept my hopes up. I thought maybe she's going to get the courage. She'll show up. If I remember correctly, we didn't cancel her flight or anything. So it was all there. And I was like, please, just board the plane, get on. But she did not. So we tried a wound case without a wound expert, which was problematic, as you could imagine. Our physician, thankfully, had extensive nursing home experience, extensive wound experience. So he was able to carry the day, but there's something substantially missing when you don't have a nurse there to add that extra context. So those were the many woes of the case, right? You don't have the injury photo that you need in the bedsore case. You don't have a good family to help you in there, all the other stuff I mentioned. So why would I try this case?
Yeah, why would you ever try that case?
Yeah, and why would I turn down 200 and then turn down 250 and then turn down 4 and then turn down 5 and turned down 600. Why would I do that when Maryland is capped at about 8? For this case, it was about 845. And the reason is the research. The research told me that the case is worth more. The research told me the case is worth $1.5, $2 million. It was a potentially multi-million-dollar case. And so if I believe the value is that much, I had a gut check with myself at one point. I said, look, if I'm being told the value is over $1 million, why would I tell my client to take less, right? Because the clients are always on the plaintiff side. They're like, we have no idea. Tell us. And I said, look, I think it's a multi-million-dollar case. The research is telling me it's $1 million to multi-million-dollar case. You tell me what you want to do. And she said, let's just find out what the jury says. So that's how we ended up where we ended up. Now, what did I find in the case that was awesome? Well, let's talk about a few of the red flags or landmines that I knew the defense would step on, and they did step on, and was hugely important to the jury. One of them was pain was a big issue. In fact, they filed a motion for summary judgment saying there's no evidence, which wasn't true, of pain related to this patient. And they relied heavily on the fact that he didn't have anyone going in there that saw him in pain. Our records that we created says that he was not in pain. And so there is insufficient evidence that he was in pain. Well, the problem for them was while their staff were systematically writing down that the guy was in no pain, every now and then, one of the nurses would do a full assessment, and what do you know? There's an assessment or two that had him in pain. So one of the things I ended up doing was I took a look at the pain assessments versus what the staff are writing in their progress notes and treatment records every shift and day, and there was an obvious contradiction, right? We have 2 times where on the same day, on the same shift, around the same time, the regular daily staff are writing down no pain, but there's other assessments that say he did have pain. All right, well, that's a problem, right? It suggests that the staff were lying about their pain assessments, underplaying the fact that he wasn't in pain. So again, these landmines, they can exist from pre-lawsuit too. And there's ways, I'm not going to get into it here, but there's ways where I've seen where nurses, staff, as soon as a wound starts, they say, unavoidable. They write unavoidable as if that's going to save them, right? But if you're paying attention, you're analyzing the records, they stepped in it if it wasn't actually an unavoidable wound, right? In this particular case, on these facts, they wrote down no pain, no pain. They're masking the fact. And you know why they're masking it? Because he didn't have family. This is the reality of what's happening in these facilities in America. They know who has the lookout. They know who's got the family member there every day or every week. This guy didn't have anyone really visiting him. In fact, the cousin, because of her health concerns and because it was during COVID, I think she maybe went into the facility once or twice in the last year or two before he died. So they knew no one's watching this guy. They could do whatever they wanted to him. And they thought that they could just write no pain. Well, we put that up in front of the jury, and they came out swinging on no pain. Now, they dropped that actually during the trial. They stopped, waving that around because they realized how bad it looks for them. They're arguing, our records say no pain, but then they have 2 assessments on the same day and shift that said there was pain. So that was a huge landmine. And the focus groups and the research told us, look, the guy clearly was in pain. What else is the nursing home lying about, right? That's a big issue. Well, let's talk about it. What else was the nursing home lying about? The death certificate that said COVID was a big issue. It was a big issue. And I think the saying is, necessity is the mother of ingenuity, something like that. Well, the COVID on the death certificate had me sufficiently worried that I sweat a lot of bullets and did a lot of research to kind of piece together what was going on. And we eventually discovered that the physician who wrote COVID on the death certificate was from the list of physicians that the nursing home offers to patients. And they basically, when the patient's original doctor, when he came into the nursing home, was not able to treat patients at that facility anymore, the nursing home basically said, hey, here's 2 doctors, and that was one of them, that's basically on our list of physicians. And so when time came for him to die, hospice didn't write down COVID on the death certificate. The only person who made that decision was the nursing home's physician, who's a regular practitioner at this facility. He has an interest. And COVID was, the guy died like in May, and COVID was in like November. So it was kind of tangential to say COVID was the cause of this guy's death. Guy's got this giant hole in his back. The turning logs show he's not being turned. They don't have documentation that they're doing it every 2 hours. And then suddenly they want to say COVID. is on the death certificate. And the jury was pretty, you could tell they were pretty upset about that. They were genuinely upset about that. Another big one that comes to mind is that there was this suggestion that the sacral wound was COVID wound because he had multiple wounds, and another one of the wounds in that buttocks area healed. Where I think if you took the time to really piece the records together, it was pretty obvious that the wounds merged. But the way they documented it made it look like the butt wound healed and went away because suddenly it disappears from the records. And they said, look, this butt wound healed, so he had the capacity to heal a non-COVID wound. Well, not really, because you can't have a wound that's like 2 by 3 centimeters disappear in a few days. That's just not a wound. It just can't do that. It defies the laws of human anatomy, right? A stage 3 wound, a pressure ulcer, is not 3 by 2 centimeters or thereabouts. Is not going to disappear suddenly. It clearly merged, and the timing of the sacral wound increasing with the disappearance of the buttocks wound made that pretty obvious. But again, it was another intangible. It was another attempt by the defense to misinterpret and misuse something because it could potentially fulfill the needle they're trying to thread. Oh, that one's a COVID wound. Regular wounds would have healed, and we were turning him in as proof of healing. It fit their story, but it didn't fit common sense. And so they just kept doing these things, the COVID death certificate, the pain, this merging of the wounds, all this stuff they tried to do to build a story that contradicted the boots on the ground, common sense facts. And if you do enough focus group research, what you will find is, lawyers get in and they say, use your common sense. We don't ever need to tell the jury, use your common sense. We could just give them the facts and they will always use their common sense anyway. And the common sense told them turning prevents wounds. The turning logs show you weren't turning. He then develops a wound. If they can make the decision based on that, all my research tells me they're going to make the decision based on that. And the defense's arguments of things like, oh, we turn, but we don't document, and COVID wound, all this stuff, those are level B, C, and D positions for juries. Can they work? Maybe. Maybe in the right case, those positions can work. But uniformly, focus groups are telling me, look, man, there's a simple answer to this, and I'm going to go with a simple answer. And that's what the focus groups and multiple focus groups and research told us in this case, and that's what the jury ended up telling us.
Can you talk a little bit about, and it's really interesting, and it's just great lawyering, because what I'm getting a sense of what you really do is you find the defenses or the things that the defense is going to at least initially try to hang their hat on. A lot of times just because that's their default. They don't really think too much through it. Oh, we've got a COVID case, or we've got a positioning and so forth. And then you dig in and you dig in so far that you almost turn what was going to be their defense into a very helpful aspect of your case that hurts their credibility, by showing what the reality of it is. With that in mind, in opening, we're taught, part of it is focus on the defense initially, focus on what they did wrong, who we're suing and why, and so forth. And then, whether you go Ball or you go, Mitnick, or your own, different take on undermining or putting things in context, we address the defenses. Can you talk about how in opening you balance, the things that they did wrong versus undermining the defenses that they're going to raise?
I have something around half a dozen different methodologies, I'll call it, I use for opening. Half a dozen different presentation styles. They're all separate. They're not a single one of them is originally mine. They're all different people's creations. They're all just been modified and bells and whistles have been added or blended by me. But it really depends on the case as to which of the half a dozen or so different presentation sequences I'll use. So it's not like one formula that I will always use.
How'd you approach it in this case?
In this case, it was straight up. It was pretty standard. It was, what are the standards, right? Standards, rules, then the story of what happened, and then the defenses. So it was it's a fairly template, which is standards, rules, story, and then the defenses. The one exception to that in this particular one, the Nelson Anderson, was I'm pretty sure I dealt with the COVID during the story, the COVID death certificate. I dealt with that during the story because it just made more sense as part of the story of what happened. I could have, put it at the end, but I thought it just made more sense. Just kind of puzzle piecing how I felt it flowed. It's kind of like a flow question is really what it came down to. If it doesn't flow in the core story, then yeah, you deal with it at the end. I rarely deal with them early on. Sometimes if it's something that's like a really good landmine, I may do that. I've done that where right out the gates early on, I'll do like a 10-second or something version of what I'm saying the case is about, and then I'll do a 10-second of what the defense will say the case is about, and then I'll say, well, let me talk to you now about the rules, so you can decide what the case is really about. So if it's a great landmine, I mean something that I know the defense really can't undo, like theoretically, I could have done that with the COVID death certificate, right? Could have said, well, the defense is going to be talking about COVID and the COVID wound and that and that, and they're going to be relying on this death certificate to talk about that. Well, we'll get to that in a little bit. Let me tell you the standards and tell you about what happened, and then you'll decide. And then by the time they get to it, they're waiting eagerly, and they find out the doctor from the facility signed it. 5 months ago, he had COVID, right? And then they start to kind of see what's going on. But most of the time, the defenses I'm going to deal with at the end. But oftentimes there will be at least a few that I deal with in the story. How do I decide whether they work in the story? Just doing it early, I think, is one of the reasons I start to do testing of the case a year before trial. Because then you have the opportunity to frame those issues and see which framing works better, right? And I'm not talking about framing to change what the story is, but there's a clean way. Theoretically, there are some of the cleanest ways you can relate to the jury what happened, and what we think is the cleanest way and the way that makes the most sense isn't always correct. It's just our subjective mind. But oftentimes, if you tell someone else that story, like I'll tell my wife the story, she'll say, I don't understand what you're talking about there. And I'll be like, shoot, well, that piece is way out of order. I got to explain that better or do a definition or something. And so doing this process that I'm talking about a year early, right, which I refer to as hijacking the defense, doing that process a year before trial helps you. Because what happened to me when I was doing auto torts, when I first started doing auto cases, is I learned it the hard way. I'm preparing for trial realistically for the first time, like a month before trial, a month and a half before trial. Discovery's closed, and I'm looking at it, and I go, oh crap, what am I going to do with this? This doesn't make any sense, or I need another puzzle piece to explain what happened here, but it's too late. And so what am I doing now? What am I stuck doing? I'm stuck doing what the defense ends up doing, which is trying to thread the needle, trying to come up with an explanation, trying to walk it away. And now I look like I'm floundering. I look like I'm giving alternate explanations, right? So the solution I came up with, it's laborious, but you just got to do it earlier. I mean, I know it doesn't work with a high volume auto practice, but with a med malpractice, I think it does work. So a year out, do the full analysis. Maybe don't do a focus group. Maybe don't do a full opening, but put together like a quasi opening for yourself of your case and just kind of look back and say, does this make sense? Do I have an actual explanation for what happened here and why? And if you genuinely don't, I mean, I've done that before, and I think to myself, this story sucks, right? And the very next thing I do is I call the client and I tell them, I think that we're probably going to get beat up and dinged. Like, let's talk about a real number, right? And I'll start that conversation so we can talk before suddenly I have 50,000 in expenses and the math doesn't make any sense for them, right? And I've done that. I've told them flat out, I think you have a real problem here with this story.
As we wrap up the interview, can you take us to the end of the trial and talk about how what did you focus on in closing, and then tell us about the verdict and if you happen to talk to any jurors and what they thought about the case.
I don't know why the jury ran out there so fast. They refused to talk to anyone. Usually when they give a plaintiff-friendly verdict, at least someone's willing to talk, but they skedaddled out of there very quick. Unfortunately, I didn't get a chance to speak with the jurors, other than one juror who told me that he was also University of Maryland Terp, and when I introduced myself to the jury, I mentioned that I'm a Marylander and I went to University of Maryland. I'm a Terp, and so other than that, I didn't get any information about their decision-making process, unfortunately. The closing for me, and I think this is not just me, that I believe this is universally understood. The jury's made up their mind by then.
Sure.
I know, like, non-jurors and TV shows, folks are under the mistaken impression that you're going to win the jury over in the closing, or you're going to say something fantastic and there's going to be this, this like epiphany and this like great moment. But if you haven't won the case by the first few days, it's an uphill battle. So I'm not reliving really all the evidence. I'm largely focusing on what is right and what is wrong, right? Like, what is right and what is wrong? Like, what really happened here to this guy? And this guy was vulnerable and he depended on the nursing home, and look at all the stuff that they did, and look at all these like alterations that they made. And I kind of focus on the themes. I very, very seldom get into discussing a bunch of evidence. I'll talk about, if I'm going to, I'm going to just highlight landmines. I'm going to highlight red flags. I'm going to the I can't get over it stuff. I'll just remind the jury of those things existed, but I'm going over the jury instructions. I'm talking about their decision-making process, and I'm talking about just good morals and what we should do. Make sure you make a right decision, and make sure that you fill out the verdict form accordingly, and don't let this family hold the bag if you really believe that the nursing home made a mistake. And I think almost all my cases are death cases, so I really go into the value of human life, right? Because this is one of the things that I think the defense, the carriers for nursing home cases are just out of their mind. They have it in their belief system that these cases are worth less because the people are so old and vulnerable. And my belief system, it's not something I say, it's not something I think I would ever say to the jury, because I don't know if they would really understand it. But my personal belief system is, if you have 10 gallons in the tank and someone steals a gallon, well, you got 90% of your tank still there. But if you got 2 gallons in the tank, or only 1 gallon, and someone steals a gallon, well, if you only had 1 and they took the gallon, you're dead. And that's what I think is happening in these nursing home cases. All right. I think they're taking the only gallon, the little bit of juice these people have left, and they're dying. Right. You can't have a 90-year-old person fall and break both hips and undergo those serious surgeries and expect them to just make it out of that. There's a high likelihood of them dying. You can't expect the 90-year-old person to have a stage 4 bone deep wound or have to get a debridement and just not die. Their body doesn't have the reserves to fight off that type of significant injury, or even endure sometimes those surgeries. And so they have to get put on hospice and dying. So my belief system is that these people are more vulnerable, and most jury instructions and case laws say this, right? The degree of care depends on the circumstances, right? And so, well, yeah, so if the person can die, you have to take that into consideration when you're caring for them. So I really focus on that sort of greater importance to being careful to not injure people who are more vulnerable. The eggshell argument, I really talk about that in the context of elderly people, so the jury doesn't fall for the belief that, oh, they're 90 and they only had 1 year left in their life expectancy, so I'm going to end up giving them only $100,000 or something. And I will tell you, when properly explained to the jury, focus groups are consistently telling me that they want to do something like $100,000 to $1 million a day for pressure ulcer injuries. Once they cross the bridge on checking liability boxes, they're pretty hell-bent on giving a proper number if it killed the person.
So, impossible set of facts, basically no family, incredibly ill client, no photographs, expert bails out, COVID infections. I mean, you name every problem with this case. What was the ultimate verdict in the case?
1,500,000, all non-economic, all pain and suffering, all in Maryland we call it a survival action, all for the deceased patient, no wrongful death damages or claims.
That's a pretty amazing outcome for those facts, and awesome explanation of the way you think about cases. I learned a lot from this, Reza. Thanks for doing this, enlightening me and anybody listening. As we wrap up, if somebody wants to get a hold of you, they want to get in line to refer you a nursing home case, what's the best way for people to get a hold of you?
Or if they want to just talk shop about a nursing home case, they're welcome to buy me a beer if they'd like. I'll put my cell phone out there. It's 301-922-4598. I invite anyone to call me or text me. I put my phone on silent when I go to bed, so worst thing I will do is not pick up if you call.
Awesome. That's Reza Davani of KBA Associates. Reza, thanks so much, man. I really appreciate you doing this.
I appreciate you having me, and thank you for letting me share my time with you.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.